sometimes some lag, so it's difficult when one of us are asking a question, but do your best to look for indicators that someone might want to ask you something. With that, I'll call our first case. It's 2019 P 1012 Commonwealth versus Jones. Ms. Kornbluh.
Good morning, Justices. May it please the court. My name is Deborah Kornbluh and I represent JAYQUAN Jones, who's the defendant in this matter. This case involves an appeal from the denial of a motion to suppress a firearm and the denial of a motion for reconsideration of the order denying the motion. On March 11, 2019, Mr. Jones entered a conditional guilty plea under Commonwealth versus Gomez to counts 1 and 2 of the indictments, which convicted him of illegal possession of a firearm without a license and carrying a loaded firearm. He was sentenced to 5 years in state prison, followed by 5 years of probation. The case revolves around an incident between Mr. Jones and Officer Philip Bissonnette of the Boston Police Department at noon on Friday, November 17, 2017. On that day, Officer Bissonnette was on a paid construction detail, a private job, with 2 other officers and working directly in front of Mr. Jones's apartment building at 40 River Street, Mattapan, where Mr. Jones lived. It was a sunny day. It was the middle of the day. It was a work day. Mr. Jones exited his building. He walked over down to the street. He saw the officer, turned around and walked back to his apartment building. Officer Bissonnette left his detail and walked 150 feet to reach Mr. Jones, who was standing in front of the building. Immediately upon reaching Mr. Jones, Bissonnette began to question Mr. Jones about whether he had a gun on him. Pictures of the apartment building, the residential apartment building, can be found at the appendix at pages 33 and 36, so that the court has an idea of the distance that Bissonnette walked when he left his detail.
Why is it significant that he walked 150 feet or 50 feet?
It's significant because it shows that, for 2 reasons, Your Honor. Number 1 is that he, first of all, could not see very much of what Mr. Jones was doing as he was walking.
Well, the judge didn't make that finding, right? The judge credited Bissonnette's testimony. And he said he saw Mr. Jones acting in certain manners, doing gun checks that would lead him to believe that he may be carrying a firearm. And so then he followed him.
That's correct, except that some of those findings were not made when Bissonnette was standing on the street and looking at Mr. Jones exiting the building. I believe that the memorandum of law that the judge filed and the findings therein, a lot of those had to do with what Officer Bissonnette saw as he was speaking to Mr. Jones. But it's significant that he went out of his way when he merely saw Mr. Jones on that day.
Well, he knows Mr. Jones, right?
Yes.
He's arrested him twice for illegal possession of a firearm. And he sees him on this day. When he makes eye contact with Bissonnette, he does an about face and he walks away. And Bissonnette testifies that he's certain mannerisms that the defendants exhibit indicate to him that he may very well be carrying a gun.
Well, the mannerisms that the judge found Bissonnette made had to do with my client walking with his arms straight, with him putting his hands in the pockets of a hooded sweatshirt in the middle of the winter in New England into a baggy sweatshirt, and making eye contact and slowly, or not quickly rather, walking back to the front of his apartment building.
Well, may I interrupt? I'm sorry.
Sure.
I feel like there are two different issues here, and I'm not sure which one you're focused on. Are you saying that the following has to do with when the defendant was seized, or that there's some problem with following someone 150 feet from your private detail because you are suspicious or targeting the person or anything?
Well, certainly Officer Bissonnette was allowed to legally walk onto this private property. So there's nothing illegal about that, but there are two issues to address your questions directly. There are two issues. Number one, the court has to decide what point in time the stop actually occurred. And then number two, the court has to make a determination about whether Bissonnette had reasonable suspicion to stop Mr. Jones at either point that this court determines the stop actually occurred.
Okay, so let's assume with respect to, I'm sorry, Judge Henry, do you want to?
No, you go ahead.
Let's assume that we agree with you that the stop occurred when the initial aggressive question was asked. Judge Meade has said, but while walking there behind your client, the officer saw him doing what the officer described as a gun retention check, and what the officer testified was something he had learned in some kind of training, was a sign that someone might have a dangerous weapon on them, a gun specifically on them. Now, you've described it as checking his sweatshirt pocket and etc. Are you saying that can't be used as part of the reasonable suspicion calculus, or do you agree that a gun retention check, like a straight leg walk or blading or these other things that we've heard about, in fact, can go into the calculus?
It can, the case law is that it can go into the calculus. But it's certainly, the court has to consider the other factors that were attendant to the circumstances on that day. So for instance, he walks right up to him, and the first thing he says to him is, you wouldn't happen to be carrying a gun now, would you? I mean, it wasn't something, how are you today or anything casual. That's number one. Number two.
Can I stop you there for a second?
Yeah.
You say in your brief that he is seized at the moment he is asked, you wouldn't happen to have a gun on you, but you don't cite any case law that supports asking a person on the street a question. Even an accusatory question is necessarily a seizure.
Well, in the cases of Commonwealth versus Barros and Commonwealth versus Wright, those are important because in both of those cases, and Barros can be found at 435 Mass 171, and Wright can be found at 48 Mass App Court 912. And in each of those cases, the officers commanded or told or asked the defendants to stop. The defendants did not. And in both of those cases, the courts reversed the denial of the motion to suppress. And in this case, when he said, you wouldn't happen to have a gun on you, at that point, Officer Bissonnette, yes, he saw him walking with his arms straight. He saw him with a hooded sweatshirt in the middle of the winter, and he had no information from on that day that my client had done anything wrong that day or any time.
Excuse me, but you've said the gun retention check counts as something. And he saw that before asking the aggressive question. So my question is, if we agree with you or assume you're right, he was seized the minute the officer said a word to him, maybe because the officer had pursued him, whatever. Let's say that's the point of seizure. Isn't there reasonable suspicion at that point anyway, based on gun retention check, prior history, repeat history of unlawful gun possession, weighted looking sweatshirt pocket, and yes, nothing by itself, but with everything else, seeing, making eye contact and turning away. Why isn't that enough for reasonable suspicion?
Because I would point the court to, particularly to address your question, Justice Rubin, Commonwealth versus Warren at 475
Yes,
Mass.
I was on that case in the appeals court.
And if under the scenario that you just described, Officer Bissonnette, you would be giving Officer Bissonnette or other officers in a position like his with my client, where they've had a history, they know each other from the neighborhood, from prior arrests, virtually any time Officer Bissonnette sees my client and my client's walking with his arms straight, or if he's walking with his hands in his pocket, or he looks away. I mean, under that scenario, just him walking away is going to be reasonable suspicion for him to stop Mr. Jones.
In the Warren case, Jimmy Warren was not seen clutching at his waist or doing what Bissonnette calls a gun retention check before he was commanded to stop. So those facts didn't occur in the Warren case that they do occur in this case.
Right, but there were other factors that the officers used to justify reasonable suspicion, and I do want to point out also that, as Justice Rubin obviously knows, in the Warren case, the court talks about the study, the FIO study, the field interrogation observation study that was done, with the police department in the city of Boston. And one of the factors that the court cited in the Warren case talked about how Black men were also disproportionately targeted for repeat police encounters. And that goes to what I'm saying now, is that virtually any time Bissonnette sees Mr. Jones, for whatever reason, the way he's walking, the way he's looking, the way he's holding his cell phone.
I'm sorry to interrupt again, but you say for whatever reason he's acting in a suspicious way. You've said that the gun retention check is a legitimate thing. That now, if you were saying there's no such thing as a gun retention check, or everybody checks to see if their keys are in their pocket and they're calling that a gun retention check, I would understand your argument a little better. But in this case, he's done something, the gun retention check behavior, that the officer testified based on his training indicates a gun, or maybe.
Well, I agree that the gun retention check is a factor, but the case law in Stout, in Martin, and in Mata all talk about a totality of the circumstances. So the court should not look at just one factor, being the gun retention check, and say that's it, reasonable suspicion, and that's the end of it. You have to look at the totality of the circumstances on that day. And
Counsel, so here we have that the officer, they had a long history. They knew each other. This wasn't a random field interrogation. He abruptly turns direction. He does what the police officer characterizes as a gun retention check. You don't think those three together give the reasonable suspicion at that point?
no, because he's allowed to turn around and walk away. It was the middle of the day, and Officer Bissonnette had no indication that my client was doing anything nefarious other than the way he was walking, the way he was carrying his arm, that he was going to hurt anybody. And again, you know, based on their history, that would essentially give Officer Bissonnette carte blanche, other officers in positions like his, to stop people that they know at any time. I see my time has expired, and if the court has no further questions, I will rest on my brief, and thank you.
Thank you very much. Mr. Lynn.
Thank you. May it please the court, Paul Lynn for the Commonwealth. The Commonwealth's position rests on the fact that as Officer Bissonnette is walking down the street behind the defendant, as any citizen has any right to do, he sees the defendant making these motions towards his waistband, which he recognizes as consistent with a gun retention check. He sees this weight in his pocket. And of course, the whole thing starts when the defendant, and granted, he has every right to do this as a citizen as well, makes eye contact with Officer Bissonnette and immediately turns around and walks back. You put these three factors together, you get reasonable suspicion. The possibility of an alternate explanation, that he's checking for his keys, that he's checking for his wallet, does not negate reasonable suspicion. Reasonable suspicion is just that. It's a reasonable suspicion, not proof beyond a reasonable doubt.
So,
And
counsel, let's just go right to the defense counsel's contention, which is that at this point, this particular person can't just walk down the street in the city of Boston, because if he touches his person at all, and this officer sees him, that he would always have the officer would always have the opportunity to search him. So what do you say to defense counsel's argument?
it's not obviously every time that the officer sees the defendant. It has to be every time he sees him, knowing that he had a prior gun conviction, seeing him make motions that are consistent with a gun retention check, seeing a weight in his pocket.
Right, so he can't use his pockets, and he can't touch his pocket.
If he engages in conduct that creates a reasonable suspicion that he's carrying an illegal firearm, yes, the officer will always be able to stop him. I mean, certainly he has a right to put his hands in his pocket. He has a right to adjust his waistband, but that doesn't mean those aren't suspicious. If I drop something under the seat of my car and I'm, in the middle of the night and I'm, reaching under my seat trying to get that thing, and a police officer sees me, that police officer might well come over and say, "Excuse me, sir, what are you doing?" And I just dropped my wallet, or I dropped something, and that's why I'm down there. And I'd say, "Your Honor, officer, I dropped something." And that was also an option the defendant did here. As counsel said, he went back to his building, and the motion judge found that he didn't go into his building. In fact, he turned around as if waiting for the officer. The judge also found they had a completely casual conversation. Granted, the officer asks an accusatory question, but the officer in DePisa asked an accusatory, but my tongue is not woken up yet. The officer in DePisa also asked an accusatory question, and the court found that isn't enough at that moment to convert it to a seizure for constitutional purposes. But even if it is, at that point, the observations that the officer has already made give the officer reasonable suspicion. The only thing he sees between that first question and the seizure is the fact that the defendant takes out this jar of marijuana and he still has the weight in his pocket. And it's his building. There's nothing, absolutely nothing, stopping the defendant in this case from saying, "I'm sorry, Officer Bissonnette. I know we're old pals, but I got to run. I got to meet somebody. I got to catch a phone call." I don't know, whatever he says. And he walks downstairs. And that's what MATA is all about. You know, the fact that people are reluctant to do that, the fact that everybody, when they're confronted by a police officer, feels some obligation to stick around and talk to the police officer. That isn't enough to create a seizure for constitutional purposes. So you put together the reasonable suspicion, you put together the fact that this gun cannot be a legal gun and the defendant is reaching towards his pockets. And I want to address one last point unless the court has any further questions. And that is, my sister argues that because Officer Bissonnette did not grab the defendant's hand the first time he reached into his pocket, that therefore he could not have reasonably been concerned about his safety the second time the defendant reached into his pocket. And the Commonwealth's response to that is that Officer Bissonnette engaged in restraint and proportionality at first. The conversation was still casual, the defendant was cooperating with him, everything is going fine, but he keeps reaching into his pockets. And at that point, Officer Bissonnette gets nervous, and rightfully so, because the defendant still hasn't explained this continued wait. He keeps reaching into his pockets. And at that point, the officer has a reasonable concern for his safety and grabs the defendant. So for those reasons, the officer had reasonable suspicion for a Terry stop from the moment he started asking the questions, even more so after up to the point where he actually grabbed the defendant, and his response to his suspicions was entirely proportional. And for all of those reasons, the Commonwealth urges this court to affirm the denial of the motion to suppress.
So, counsel, it does seem like a police officer who knows the defendant and knows his history and then sees the police officer and then touches his clothing, that it seems like your argument is that he could be stopped. I guess I'm wondering how far that goes. So if the officer stops him 5 times and he never has a gun on him those 5 times, and the officer stop him a 6th time, a 10th time, a 20th time, like at what point does the calculation change?
As my sister pointed out, the inquiry turns on the totality of the circumstances. So if there was some evidence that he'd stopped carrying guns, that he had never had a gun on him in a year, obviously it's going to depend on the facts of an individual case, but and the difficulties of line drawing. But that's part of the totality of the circumstances analysis. Here, he had just been convicted in 2016. He could not even have been out of custody long when Officer Bissonnette sees him making these suspicious actions. So we are clearly on the reasonable suspicion side of the line here. The fact of the defendant's prior conviction here, recent prior conviction for illegal gun possession, is a very important factor going towards reasonable suspicion in those circumstances. If there are no further questions, the Commonwealth will otherwise rest on its brief.
Seeing none, I'll thank you both.
Thank you, Your Honors.
Okay. And we are live.
Good morning. Welcome to the Appeals Court. Our next case is 2019 P927 Commonwealth versus Burke. Mr. Hahn.
Yes, good morning, Your Honors. My name is Alex Hahn. I'm here on behalf of defendant LINNEA Burke. This case is about 2 things. First of all, the weakness of the Commonwealth's case, and I think it is weak indeed. And second, improper statements made by the ADA during closing argument. Now, the Commonwealth tells us in its appellate brief this morning that the statements made by the ADA, even if improper, did not go to the heart of the Commonwealth's case and thus were not unduly prejudicial. I think this overlooks and somewhat begs the question as to why the ADA led with this issue and forcefully and prominently made reference to a witness who did not testify. Here's the statement made by the ADA. You heard how it wasn't just the trooper you heard here on the stand. There was another trooper who interacts with the vehicle and decides whether or not to wave them away. What the ADA is doing here is asking the jury to infer that there is cumulative and additional evidence of the defendant's insobriety.
Mr. Hahn,
Yes.
but all of those things were testified to by the trooper. She's perhaps arguing things chronologically, how the event starts, and these things did occur, so they're not facts, not an evidence. The ADA does not argue that the initial trooper formed an opinion of any kind. He just waved her on. And don't you think the heart of the Commonwealth's case is really the field sobriety tests and the second trooper's interaction, all the things he sensed and smelled, her inability to stand up, her failure on all the field sobriety tests? That's the heart of the Commonwealth's case, not someone waving them into the pit area.
Yes, Your Honor, and I would certainly speak to the field sobriety tests and disagree somewhat that she failed the test. But I do think these statements are important. So I think you're absolutely right that there was testimony concerning what happened in terms of Ms. Burke and other drivers being waved in, but there was absolutely no indication that that was somehow suspicion-based and anything other than random. And to the extent the second trooper was on the jury's mind at all, I think they reasonably could have concluded, sort of based on life experience, that this was something akin to being removed from an airport security line for further inspection. And as we know, that's random.
Counsel?
Yes,
Does our case law permit the officers to have some preliminary screening and then wave people away and wave other people into the pit? Or does someone have to fully come in or fully stay out? And I'm going to ask the same question of the Commonwealth.
So the case law does allow a preliminary determination. So it is based upon some sort of threshold determination of a concern that would thus warrant additional testing. So that is the case, but my concern is that the jury didn't know that, and they didn't have any reason to know that. Again, the testimony does not speak to that. It does not get into why. I mean, so the jury, to the extent they're thinking about this at all, and I'm not sure they are thinking about the second trooper at all, I think they could reasonably conclude the opposite, you know, again, based on life experience, that this was random, not suspicion-based, because as we know in sort of the airport context, the idea is to avoid prejudice or the appearance of prejudice. So I think that could have been the assumption of the jury, to the extent there was an assumption at all. But that assumption is dispelled by the prosecutor. And again, there has to be a reason why she's doing this, why she's mentioning this, and sort of, again, creating that inference of a suspicion-based decision to waive Ms. Burke and other drivers in. I just think
Mr. Hahn, this wasn't objected to, correct?
It was not objected to, Your Honor.
It didn't leave the defense counsel with the impression you're asking us to draw now, that something was amiss here.
Yes, and I can't speak to the internal process of defense counsel, although obviously there are many cases where issues were not preserved, but that still can amount to a miscarriage of justice, and that's
True.
Ultimately the standard. And I think Justice Meade, you did raise the issue of the field sobriety tests. And I believe that's sort of the problem with this case, is the weakness of the evidence on those tests, coupled with these statements, which I do believe ranged beyond the evidence, viewed against the backdrop of evidence that was weak indeed of the defendant's insobriety.
Well, you say it was weak. She said she'd been drinking Tito's vodka, and then she failed the straight line test every way you can fail it. She was unbalanced at the beginning. She didn't do heel to toe. She used her arms to balance herself. She had 2 steps outside the line. She went to 10 steps instead of 9. I mean, you can say that you think she didn't fail, but it sounds like she failed in every possible way.
Certainly, I understand, defer to Your Honor's interpretation of the facts, if that's indeed your interpretation of them. I mean, my sense is, just viewing the evidence in the aggregate, that it was somewhat in equipoise. And in terms of the walk and turn, I think on the face of it, it's a challenging test. And she makes it 5 steps, briefly steps off, and then resumes. And as I understand it from the testimony, turns and then makes it the rest of the way back. So I would view that test as in equipoise as to whether
But Mr. Hahn, as Justice
Yes,
Rubin
Your
said, she can't count correctly. She can't walk heel to toe. She can't keep her balance. That is not in equipoise with sobriety.
Your Honor, I would look at also the other tests that were
Well, before we do
undertaken.
that,
Yes,
you do focus on the 9-step test, and there was also no objection to this testimony, and your argument on appeal is that you didn't like the way the trooper conducted the test. But how do we don't have a record to say he did it wrong, correct?
Well, I think from the testimony itself, it's ambiguous. I mean, so there's the indication in the testimony about some degree of quote unquote wiggle room that you have in terms of it being your heel to toe, which has to be flush. But the trooper doesn't appear to understand that concept particularly well. I found the testimony a little bit garbled. So I think in the administration of the test was questionable. And I think overall, I mean, just from a matter of basic fairness, this trooper was extremely inexperienced. He was working under the supervision of a coach who was not there.
But I don't understand. You're saying you can't. Are you saying that the test therefore is inadmissible because you don't like the way it was administered?
I think overall, as a matter of due process, when we aggregate together all of the tests, the evidence was insufficient as a matter of law, and that the motion for required finding should have been allowed. And I'm happy to elaborate on the other tests.
No, go ahead.
Yeah, certainly. So on the 1-leg standing test, I believe she passes that test. She's holding her leg out, and the trooper's concern is that it is slightly bent, but I think that could be explained by any number of factors, not being limber enough to extend your leg fully. But he
didn't test. There was no indication that she had an inability to perform these tests, right?
Exactly. I mean, so
what you're really illustrating is your view of the evidence or conflicts in the evidence, which are really questions for the fact finder, aren't they?
Well, again, every element of the crime must be satisfied under the Lattimore standard. And
yeah, but you're not viewing the evidence in the light most favorable to the Commonwealth.
Well, I think if we look verbatim at the transcript, the trooper testifies, I believe it's a direct quote, that she held for 30 seconds. So I think she essentially passes that test based on not my gloss on the evidence, but on the plain text.
Why would the trooper have arrested her if she passed all of these tests?
Well, I think what I'm arguing here is that there was not a legitimate basis for this. And even if there was, I think the matter before us is somewhat different. And even if there's probable cause for an arrest, I think that the matter of whether the case is proved beyond a reasonable doubt is a different matter. And that when we look at this evidence in the aggregate, that test, which again, I would venture that she passed, and then the alphabet test, she proceeds through the whole alphabet from A to Z. The main concern seems to be that she should have started at the letter M, but it appears she makes it through the alphabet. So I don't.
But she did not follow his instructions, which were to start at the letter M. Instead, she does the whole alphabet, which a reasonable inference from that is that she's impaired.
Well, I think if we look at this in the aggregate, I mean, she makes it through the entire alphabet, and I think the explanation could be any number of things as to why she starts with M. I mean, I think we ordinarily.
But Mr. Hahn, under Lattimore, the Commonwealth doesn't have to exclude hypotheses of innocence.
That is absolutely true, Your Honor, but it does have to satisfy each and every element of the crime, including sobriety, which, again, I think when we put these together, I would view it as a matter of equipoise, and that coupled with, again, I mean, I know that the judge's remarks amount to nothing more than color as far as the record, but he does say at the end of the transcript that juries are unpredictable, which I think, reflects his somewhat surprise and beguilement as to this verdict, looking at this evidence in the aggregate. As being insufficient as a matter of law. So I think that, let's assume the jury did go into closing arguments with some doubts about this evidence, perhaps being an equipoise. What's ringing in their ear is that another trooper made some sort of determination of sobriety. Again, she leads with this argument. It's prominent.
Did you make a motion for required finding below?
Yes, Your Honor, I believe there was a motion for required finding at the close of evidence. Okay. So I think that we proceed under the standard Lattimore.
Sure, I mean, insufficient evidence is always right, but I'm just thinking, you mentioned the judge saying something suggesting he thought the evidence was insufficient, but you asked him, or the lawyer below asked him if he did or she did, and the judge said no, right?
Yes, Your Honor. I mean, I view that as kind of color here. It's true the judge denied that motion, but I just found it somewhat interesting that the judge, I mean, his surprise was that there was a conviction, it would appear. And I, again, very respectful of the court's interpretation of the evidence, but I believe, based on, an overall view of this evidence from sort of soup to nuts is about a 50-50 proposition as to whether or not she failed these tests. On the matter of the Tito's vodka, and I think it's somewhat telling that the officer asked no follow-up questions. We don't know when she drank this vodka. We don't know how much. I mean, these are the most obvious questions in the world to ask. And
we do know that she smelled of alcohol, and we do know that her speech is slurred.
There's no question, I think, that there, was some alcohol consumed, but the question is, do we get to the level of impairment of proving
rather than asking questions, the officer had her get out of the car and do some field sobriety tests, right?
Indeed. So we have, his observations, and another thing he says, and this is a direct quote, that she was a little unsteady on her feet. So a little unsteady. Again, I don't think it's compelling evidence at all based on his observation. And then secondly, the test itself, again, on the walk and turn, she makes it all the way back. I mean, as Justice Meade observed, it was 10 steps rather than 9, but she makes it all the way. And this is a complicated test. None of us necessarily engage in experiments, prior to these matters, but I think these are difficult tests for anyone even not impaired.
It's not the most complicated test.
Well, if toe flush to heel, I guess my own dexterity falls below that of the courts, I imagine. But I do find the matter of putting toe to heel, I think it's arguably somewhat impressive that one is to make it 10 steps. And I think that if one is, it doesn't prove that she was not impaired, but it leaves that evidence in equipoise, in my view. I see my time is virtually up, so if the court has no further questions, I'll rest on my brief.
Thank you.
Thank you very much, Your Honors.
Yep, unmute yourself, Ms. Robson. Oh, Brittany?
There we go. Good morning, Your Honors. May it please the court, Mary Rose Robson for the Commonwealth, arguing with leave of this court. With me also is Assistant District Attorney Monica Delator, and we are respectfully asking this court to affirm the defendant's conviction of operating under the influence of alcohol. And I'd like to jump straight to the sufficiency issue, where the defendant's motion for a required finding of not guilty was properly denied, where the Commonwealth presented ample evidence that the defendant was guilty of operating under the influence. And I would point to the court to the following 6 facts, where first, the defendant slurred her speech at transcript sites 27, 31, and 46. Second, she presented with glassy eyes at transcript site 27. Third, she smelled of alcohol at transcript site 27 and 35. Fourth, she admitted she had been recently drinking Tito's vodka at transcript sites 54 through 56. Fifth, she walked with an unsteady gait at transcript sites 28 and then 36 through 37.
Recently drinking, or did she just say Tito's vodka and the officer didn't follow up?
She said the trooper testified that she had said the word recently, but they clarified on cross-examination that they couldn't determine how recently, time-wise. And lastly, she also failed all 3 tests of the roadside exercise. And just to go deeper into that, because my brother spoke about that in depth. First, about the 1-leg stand test, the defendant was slow to lift up her foot and was slow to begin counting. And throughout, she counted incorrectly with slurred speech, and her leg was at a sharp bent angle as opposed to straight like he instructed. And a lot of these tests are about whether the defendant can follow the trooper's instructions. Second, during the alphabet test, she continued to slur her speech, and she didn't recite the correct range of letters, again, emphasizing that she couldn't follow the trooper's instructions. Third, as was mentioned,
The fact that the alphabet test is not a standard test, and in fact, many people would have trouble starting the alphabet at the letter M. In fact, I mean, I could ask you to start at the letter M right now, and you might have a hard time doing that. And it's a non-standard test.
that's true. It's just one of many indications, though, that culminates in sufficiency of the evidence. And it is accompanied by the walk-and turn test, which was discussed in depth, where the defendant had to step off twice from her starting position in order to stay on her feet. She also failed to walk to heel to toe. There is wiggle room, as the trooper testified, but the trooper also testified that she went beyond that, which was allowed. The defendant also stepped off the line at steps 5 and 7, made an improper turn, and took an incorrect number of steps in both directions. And again, I just emphasized that she couldn't follow the trooper's instructions. And going to the closing argument issue, the trooper testified specifically about the initial setup of the roadblock, where there is an area that's coned off, and the initial trooper, and this is all on transcript site 33, the detective stands there and, quote, that person is the person who detects and waves people in. Additionally, he said later on that page that vehicles are funneled, so they're almost stopped, and the trooper talks to them for a little bit, and then they're waved in. So all of the statements are grounded in fact, in the evidence that the trooper testified to. And I would emphasize too that the defendant didn't object to the statements. The statements were made at the beginning, as my brother mentioned, but they were context. They were set up to the primary facts. They occurred right at the beginning, and immediately after, the trooper then went into talking about the defendant's failure of the roadside exercise. And the statements regarding the initial state trooper.
Counsel, do you agree that the implication of referring to this other trooper was that this other trooper was making some sort of evaluation of the question, at least of the driver's sobriety?
I would point the court to Commonwealth v. Murphy at 454 Mass 318, where that kind of determination can be made, as well as they can make a brief greeting. We didn't brief this issue, but we'd be happy to supply 16L for the court after the arguments. So I think also—
What's your answer to Justice Henry's question? Do you think that the implication of this is that the first trooper made some kind of assessment?
It's unclear from the trooper's testimony exactly on this issue, but again, the testimony that we do have available is that he detected and then waved the defendant's Toyota Corolla into the pit ultimately. So I think there was a surface level determination there, but we have no evidence, again, basically that we know of on that issue.
Well, counsel, I think that's the concern, that we have this little bit of testimony, and then that the implication in the closing argument was drawn that this, you know, and we all have to start somewhere. We all have to have our first court appearance, or we all have to do our first unsupervised sobriety checkpoint. But that the implication was that this particular trooper had almost no experience, and that, you know, this was a way to bolster their credibility by referring to another potentially more experienced trooper who made their own evaluation of the driver.
So the statement was that the trooper detected, and it goes in with that inference, but the prosecutor didn't argue the inference. Instead, the defendant on cross-examination was free to ask about the initial trooper, but chose not to during the initial trial. And furthermore, these statements regarding the initial state trooper at the sobriety checkpoint didn't implicate the trooper's observations and ultimate opinion that the defendant was intoxicated. The prosecutor's statements did not go to the heart of the case, and his opinion was instead based on the defendant's poor performance of the roadside exercise, not on the first trooper's decision to wave her car into the pit. Because ultimately, this case is really about the defendant's capacity to operate a motor vehicle safely. And she failed every test, and the trooper's observations about her demeanor and her appearance backed up those failures of the roadside exercise. And furthermore, the trial judge provided strong instructions to the jury that would have mitigated any potential prejudice from the prosecutor's statements. I would point the court to transcript sites 18, 20 through 21. Before the case even opened, he says, what's said in the opening and closing statements aren't evidence. And then he also spoke about speculation on transcript site 68. You're not to engage in any guesswork about any unanswered questions of fact, or speculate about what the real facts might have been. You can only focus on the testimony. And on 71, the closing arguments of the lawyers are not a substitute for the evidence. And finally, the statements couldn't have impacted the jury verdict in light of the substantial incriminating evidence against the defendant, satisfying the tests in Commonwealth v. Imbert at 479 Mass at 586. So with that in mind, the claim to error in the context of the evidence, the judge's instructions, and the strength of the Commonwealth's case, there could be no substantial risk of a miscarriage of justice. If there are no further questions,
No.
The Commonwealth will rest on its brief.
Thank you all.
Okay, we are live.
All right. The next case is 2019 P934 Commonwealth versus Rodriguez. As an ordinary case, each side gets 15 minutes. There's no rebuttal. Try to be conscious of the judges trying to ask questions. There seems to be a slight lag. But with that, we will begin with Mr. Hirsch.
Thank you, Your Honor. If it pleases the court, David Hirsch representing Mr. Rodriguez. I'd like to begin my argument with a bit of history of SDP cases. We had the Johnson case where the court for the first time said one of the QEs must find the person sexually dangerous for there to be a commitment. Then we had Green, where the court said, well, obviously, if that's the law, the jury has to be advised about that. Then we had the series of cases starting with Suave and others, where the court set forth two new requirements for commitment, either a contact offense or the non-contact offense that would likely create apprehension of a contact offense. And then in spring, the court said, well, obviously you have to tell the jury this. We have the same situation a third time over here. In spring, for the first time, the court said specifically, possession of child pornography is insufficient for commitment. And now I think the court faces the same issue it faced in Green, the same point it faced in Green and in Spring, namely that the court has to tell the jury what the law is under the new interpretation provided by the Spring case. Now, I understand Spring.
Excuse me, I'm sorry to interrupt. Spring said that the failure was the failure to give the suave instruction. Here, the suave instruction is exactly what was given in response to the question. So why weren't they told by the suave instruction exactly what they had to find?
Because Spring takes things one step further than suave by stating that it's not enough, that possession of pornography is insufficient.
So are you saying that the suave instruction is no longer adequate in all cases where this is an issue? That there has to be an explicit instruction and mere possession of child pornography by itself is not adequate?
Your Honor, I don't think this case requires the court to determine whether it's necessary in all cases. It's certainly necessary in this case for a specific reason, because the jury made it clear that even with the suave instruction, they didn't understand the rule of Spring that that possession of child pornography is insufficient. That's
Mr. Hirsch, in Spring though, unlike here, the judge actually told the jury that they could find Mr. Spring sexually dangerous merely through the possession of child pornography. And that didn't happen here.
If I recall properly in Spring, I think the trial judge did not mention child pornography and just did not give the suave instruction. So I think here in suave, this court announced that it was necessary to give in Spring, this court declared that it was necessary to give the suave instruction in part because the jury made it clear they didn't understand without it.
This jury twice got the suave instruction, right?
And yet still did not understand the point that child pornography was not possession of child pornography.
How do we know that? Wait, how do we know that?
Because of
we know they didn't understand.
Because of the question they asked.
And then they were instructed again under suave, and they did not come back with another question along the lines of "we do not understand."
Well, Your Honor, at that point, I think another question would have been futile. They had asked the question, the answer they got was the same instruction that they got before. It would have made very little impact for them to try again, I think. I think few juries would try again. The point is here, you asked, how do we know that they didn't instruct it? I think that is evident from their question. There would have been no need to ask the question if they did understand that.
Am I right? They had the jury instructions with them in the jury room. So when they referred to page 14, it meant they had read the suave instruction that they had right in front of them, didn't apparently understand or know that that meant no mere possession of child pornography isn't enough. So they asked, and they were re-instructed with exactly the language they had been reading in the jury room. Is that right? They had the instructions?
Yes, Your Honor. And a repetition of something they didn't understand the first time can't be sufficient the second time. If I may move on to the next issue, the sufficiency of evidence. This is an issue of first impression, I believe, Your Honor. If I may for a moment. The question is whether it's enough for a qualified examiner to say the word menace, or must the qualified examiner go through the points, the requirements for commitment. Is it enough for a qualified examiner merely to say he meets the criteria? If that's so, Your Honors, there's an incentive to ignore those criteria and for the QEs to impose their own standards. It gives them vastly too much leeway unless they are required to meet the criteria. We have case law saying that every element must be proved. Now, is every element proved when a judge just says menace? I would argue that it is not. The next argument—
Didn't Dr. Gans testify that he was a menace?
Yes, and I am saying, Your Honor, that just saying that somebody is a menace is not
Under the
sufficient.
statute.
I'm sorry?
She said that he was a menace as understood under the statute, right?
Yes, and then she continued. She said, well, actually, before that, she said, well, there's some reason to believe, I don't remember the exact word, some reason to believe he may commit a contact offense, but she never, in fact, she avoided the issue of whether Mr. Rodriguez was going to commit one of the two kinds of crimes required for commitment.
Counsel, why is that not a matter for cross-examination?
Your Honor, under Camblin and other cases, the key is, this is not an issue just for cross-examination. It must be established as a matter of due process in the witness's testimony. Camblin is the key here. If I may move on.
Obviously, but just to be express about it, you agree that mere possession of child pornography does not satisfy the Suave test, right?
Oh, yes, Your Honor. As far as the interpreter deficiencies go, Your Honors, I think we've known, at least since Johnson, that the 60-day evaluation by the qualified examiners is the key pretrial element in these cases. Here, the Commonwealth's experts largely relied on their interviews of Mr. Rodriguez and on the interviews done 2 years earlier in the comprehensive evaluation. But since all of those evaluations were done by aid of an unknown interpreter over the telephone, we have absolutely no way of knowing what degree of accuracy.
But Counselor, this is an interesting argument to me, and it seems to me that maybe in a proper case, the statute requires a certified interpreter. But you didn't raise this below, at least not this way. So we'd have to find a substantial risk of a miscarriage of justice. We don't even have an affidavit from the defendant saying, they say I said, quote, blah, 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 unquote, I did not. There's no evidence at all of an error. So how can we find a substantial risk of a miscarriage of justice?
Because, Your Honor, there cannot possibly be a record. How can somebody
remember what they told someone?
Well,
how can you remember if they said, I'm still attracted to boys, or I wish I could touch them? I mean, either you said that or you didn't. That seems like a pretty, and I understand there are cognitive impairments here and so on, and maybe that's a matter for a motion for a new trial or something, because it's all, I mean, I hear IQ of 77, and obviously there are some flags attendant on a test score like that, but I just don't see how. You're saying in every single case, I mean, it doesn't look like a structural error to me. It's not even maybe constitutional.
Well, Your Honor, in Adam Soto, which I may be mispronouncing, the court said that there was no substantial risk of a miscarriage of justice because the defendant's statements, as reported by the interpreter, were not inculpatory on the central issue at trial. Here, the statements are the key to the trial. We don't know if they were accurate. And how can we ask Mr. Rodriguez, who can't speak English, who can't read, to figure out if the translation is correct? It would require bringing somebody else in to retranslate it.
Well, I assume counsel, his lawyer, was able to talk to him through an interpreter or otherwise. How was he defended without interpretation? I don't understand that.
He was defended with interpretation.
So someone can say, it says in the report that you said I'm attracted to boys, or whatever, and he can say I didn't say that. I mean I'm just making this up, but
yes, that's the point, Your Honor. I could say it. You could say it. I don't think Mr. Rodriguez can say it. He mentioned the 77 IQ, which may well be an overestimation, because we also have the evidence that he's in the bottom 6% of cognitive skills, that he had this third, fourth grade education.
Didn't the primary witness that the defendant relied on, the QE, Dr. Bell, also used an interpreter?
Of course.
Yes.
Your Honor, we didn't hire Dr. Bell. The defense didn't hire him. The defense has no control.
He's a QE.
Yes, the defense has no control over how any QE does his or her job. Now, the fact that Dr. Bell's testimony may have suffered from the same problem is irrelevant here. We're talking about whether the evidence was sufficient, and that goes, excuse me, not whether the evidence was admissible, whether the evidence, this key evidence was admissible.
I'm sorry to interrupt, but the problem, and I think that Justice Rubin illustrated, is that we don't know whether there are any mistakes. There aren't even claimed mistakes.
That's how come we have to assume prejudice, because we can't know.
I'm not familiar with a case that lets us do just that.
I would say that because we don't know if there was any, I believe it's the Commonwealth's duty to establish the reliability of its evidence. Do we know if the evidence was reliable?
This was not, excuse me, this was not objected to, right?
Correct.
So therefore, let me finish. Therefore, it is not the Commonwealth's burden, it is your burden to show a substantial risk of miscarriage of justice. And on this record, I don't see how you can, and I also don't believe you argued that it was structural in your brief.
Your Honor, I believe I think I suggested it was structural. I cannot find it at this moment. The only other point I would make is that if under, go back to Adon Soto, if we, in that case, they didn't determine whether there were mistakes, they merely said that because it wasn't a central issue regarding culpability, there was no error. That's the difference. And we did object to the admission of the comprehensive evaluation on the same grounds.
Are there any other questions, Justice Henry or Rubin? No, thank you. All right, your time is up, Mr. Hirsch.
Thank you, Your Honors.
Mr. Steinfeld.
Thank you very much. May it please the court, Kenneth Steinfeld for the Commonwealth. Can the justices hear me all right?
Yes.
Great. I'd like to start with the last point that Mr. Hirsch talked about, which is the translation issue. Adon Soto itself says that where there's no evidence that anything was false or wrong or badly interpreted, there's no substantial likelihood of a miscarriage of justice. This is absolutely not structural error, and I do not believe that the defendant even mentioned or talked about or even contemplated structural error in his brief. I did raise it in mine in a footnote because I found some interesting cases about the applicability of structural error in civil cases, but this is just not one of them. Under Adan Soto, he certainly has to show that he didn't say anything, and has been pointed out by Justice Rubin. He didn't say, I didn't say that I want to touch boys, and that I still, at the age of 69, 70, 71, 72, still have a sexual attraction to children and I want to touch them. He never said he didn't say that. So he's not even come close to showing any kind.
Is there a way for a person in Mr. Rodriguez's position to have a certified interpreter?
Yes, as far as I know, there is. The experts testified that that is just what is commonly done at the treatment center. That's just how they do it. As Dr. Bell said, that he's never had a problem with it, and that's just how it's done. But I imagine that if somebody, if an attorney wanted to have a certified interpreter present for a QE interview or in an interview by some other STP expert, you can certainly arrange to have that happen. But there's been no showing that this is not a common practice among these practitioners when they formulate their opinion, is to use this telephonic service, which, as Adan Soto explicitly says, that that's okay for police interviews. And in fact, all they said in that case is that it had to be taped, but they said nothing in that case that there was something problematic about the use of a telephonic service for that. The jury were made aware of this issue.
Counsel, are these interviews recorded?
No, and I think that a finding, the defendant asked in this case that this court make it a requirement that these be recorded, which I think would take a lot more evidence than is in this record to determine if that's a good idea. I'm sure that there are psychiatrists and psychologists who differ on the issue of the efficacy of having it tape recorded. It's certainly going to have some impact, I think, or at least arguably, on the honesty and the truthfulness of the patient or the person being interviewed. So these are not ordinarily tape recorded, nor do I think that it would be necessarily a good idea to have them tape recorded. We would need a full hearing on something like that, just as was done in Di Giambattista. So the answer to the question is no.
Can you talk, Mr. Steinfeld, about the jury's question?
Sure.
So they have the Suave instruction physically in front of them.
They do.
They read it, and yet they have this question.
Sure.
That you would think might be answered by it, although I can imagine someone thinking about the fear of the victim being the victim being the person who is depicted in the child pornography. I'm not sure exactly what they're thinking, but something. They ask, they say, with reference to these very words, do they mean X? And the answer they're given is these very words. Is that adequate?
Yes, absolutely. In light of the fact of what those words are, I do agree that I have a much stronger case if there's no such jury question. That certainly brings up something, but we cannot read too much into it. It may have been just one juror was not sure, or a few jurors didn't have an idea, or perhaps they thought they knew what it meant and weren't 100% certain. They thought it meant what it said, and they said, maybe perhaps we can get some kind of clarification from the judge. And so they asked that question. But what they were left with afterwards was just the instruction that had been given to them twice by the judge orally, plus the words. And if you look at the words, he divides it up into two categories: contact offenses and non-contact offenses that would instill a reasonable apprehension of fear of a contact offense. If you then apply those words to the facts of this case, it is almost impossible to think that the jury would find that, okay, we only think he's going to possess child pornography, and at the same time, we think that that satisfies the language. So I think, in fact, the words of the instruction itself, in light of the evidence of the case, yes, but I do agree that it certainly, it does raise an issue.
They asked, they were like, can we? You know, I mean, I understand we don't know what that's about, but I don't know how you would find out what it was about either. You know, all you have is this question. Let me ask you this, in light of Spring, going forward, prospectively, is a defendant entitled to an instruction if they ask for it that says, you may not, in a case like this, mere possession of child pornography standing alone. I understand we can come up with situations where he's the producer of the child pornography, or, you know, or he's using it.
Use it to lure a child, or,
yes, or you know, all these different things. But are they entitled to an instruction?
No, they're not. I don't think that it's an abuse of discretion or legal error for such an instruction to have been given in a case, but I don't think that this court should mandate or needs to mandate. Fay and Suave are perfectly clear and adequate, and a judge's role, of course, when instructing the jury, is to convey the law adequately so that the jury understands it. Yes, they did ask a question in this case, but I don't think that you conclude solely because of that they misunderstood. I think that it might be an open.
I'm sorry, you go ahead.
I'm sorry, Justice Henry, I didn't see you.
No, you're fine. I think what the defendant is arguing is that by repeating the instruction, we are leaving open the door, the possibility that the jury could find him to be a sexually dangerous person based on the mere possession of child pornography, and that due process would require, we can't leave the jury in that position, that we should give them a clear answer, not an answer that one could say was legalese.
Well, I would go so far as to say that it would be a sound practice for a judge at that point, having been asked, but I don't think that it is reversible error for him not to have given. I'm not sure if that fully answers that question.
The Suave instruction,
yes,
the final part of it says something like put in fear, in immediate apprehension or something of a contact offense. It doesn't say of a contact offense being committed by the defendant.
Well, I believe that the instruction said something about put his victim, instill in his victim, that is the defendant who's perpetrating the act, instill in his victim a reasonable apprehension of a contact offense.
I'm trying to figure out why a jury would ask this question. And the only thing I've been able to come up with is, and I think it's a misunderstanding, but if they thought, and there's an illogical leap in this, but if they thought, well, there is a victim, it's the person being filmed or photographed or whatever, and someone watching that, creating demand for this kind of child pornography, in fact, puts that child at risk of further physical contact and harm. Now, of course, the logical leap is that victim can't know that this defendant is watching the child porn when it happens.
I agree with everything, yes.
But I'm just trying to figure out what they could have meant. And that's the closest I come, is that maybe someone's in fear of contact, not from him. It's his victim in some sense, but that child would be put in fear if they knew somehow that this guy was doing this, of contact by their abuser.
I theoretically agree that it is possible that if one were to parse the language of the instruction exactly like you say, that they would, in theory, possibly find that the sole possession of child pornography was enough to find somebody STP. I think the likelihood of that is infinitesimally small and de minimis, and that this defendant, who merely says reversal is required, that's his entire argument on prejudice, which is insufficient, has not shown that there's a likelihood of that, a probability of that, or that there's a substantial risk, or I'm sorry, that there was prejudicial error, because it was certainly preserved. And so the fact that one could theoretically just imagine that that might have happened, I don't think is enough to reverse a finding of STP after a full trial.
Can jurors be interviewed after the fact?
I have no knowledge of that. I'm sorry, Your Honor. I'd be happy to submit a letter, but I am woefully ignorant of that subject.
I don't think we need a letter. We can.
Pardon me, Judge, I didn't hear you.
I don't think we need a letter. Thank you.
Okay. Lastly, on the sufficiency claim, I've got a very short argument. My brother says that it's a claim of first impression, and I think it's a claim of very, very frequent impression, and that the general rule from the cases I've cited, a lot of them are 128s, but I think they're exemplary, is that when you have a defendant who's convicted contact offenses in the past, many of them, plus you have experts who testify that he meets the statutory criteria, plus you have evidence of present sexual deviancy and arousal by children, that is sufficient evidence. I don't see anything distinct about this case that would separate it from all of those other sufficiency cases. And as to the term menace, there was plenty of evidence that the defendant was a menace, even though Dr. Gans did not admittedly then go on to say menace means. The jury were told what menace means through the through the Suave instruction. So I think that there was ample evidence, more than sufficient evidence.
I just didn't hear you. You said the jury was told what menace means by the what?
By the Suave instruction.
Thank you.
Not directly, but implicitly. I mean, yeah, she said menace. She said all the things that you have to say, and they were supported by the record, which is sufficient as long as the jury were properly instructed, as they were here, about what sort of future offense the defendant has to be found likely to commit. And if the members of the panel have no further questions on the other issues, I'm happy to rest on my brief or to take questions.
Seeing none, I'll thank you both, and we'll take this under advisement.
Thank you very much.
Okay, we are live streaming.
Great. Welcome to the appeals court. Our next case is 2019 P74, Department of Children and Families versus Father and Another. As you all know, this is impounded. This is being broadcast on YouTube, so please don't use any names, descriptive terms or pseudonyms that you've chosen already. With that, we'll start with Mr. Young.
Thank you. Good morning, and may it please the court. Robert Young, and I'm representing the father. The heart of the father's argument here is pretty straightforward. Basically, that his past parenting deficits no longer existed by the end of the review and redetermination hearing in April of 2017. But the judge failed to focus on the relevant time frame when assessing the father's current fitness. She engaged in a backwards-looking analysis, reaching far into the past and marshaling a constellation of facts that fell within three general categories. And first was the past relationship with the unfit mother. Second was the father's history of alcohol and substance abuse. And third was the father's mental health diagnoses and history. And in turn, starting with the past relationship with the mother, that's really where this case started, way back in 2014, when the child was born substance positive at birth, and was shortly within, I believe, about a year removed from the mother twice. Unfortunately, during that time frame, the father was also struggling with his alcohol addiction and was unavailable to assume full custody of the child because he was serving a sentence in jail. The other piece that the judge, as far as the relationship with the mother, focuses on is the history of domestic violence, which it actually occurred and ended before the child was even born. And the father's restraining order that the mother took out against him, I believe, expired in 2012. The important piece here for this relationship, much like the other parenting deficits the father demonstrated historically, was his alcohol and substance misuse affecting his behaviors. So when he ended his alcohol and substance abuse, shortly after ending his relationship with the mother.
I'm sorry, didn't he test positive for an opioid on the day of trial?
So there were two within the bracketing, I would say, the time frame that the father is pointing to. The father stipulated, along with the mother, to unfitness in January of 2016 on the eve of the originally scheduled date for the trial. At that point, he had a positive drug screen, yes. Then shortly after that, he engaged in treatment with Clean Slate, opioid treatment, beginning in March 2016. A year later, March of 2017, at the end of March, when the review and redetermination hearing began, he tested positive for, I believe it was oxycodone and marijuana. Now, his testimony was that he had, on the eve of trial, he had some dental work done, and he was prescribed that. He took one, I believe, and threw the rest away, and he tested positive.
Yeah, but the judge doesn't have to believe that. The judge said that his story about the teeth was inconsistent.
Well, that may be the case, but prior to that positive screen, he was being screened regularly through the treatment program, and the only positive screens he had during that year of treatment was for marijuana, which the treatment providers didn't appear to have a concern with. He did not test positive for opioids. So setting that aside, he maybe not made the best judgment as far as taking that pill after having the teeth removed. But whether he had 2 or 3 teeth, there's nothing in the record to contradict that the fact that he had that surgery. In fact, the review and redetermination hearing continued for another, I believe, 3 or 4 dates till the end of April, and no one made another request to screen him again. So that does sit out there as problematic, but that alone, knowing the arc of substance addicted individuals that relapse and recovery is part of that. He didn't consider it a relapse. His providers didn't appear to consider that a relapse. Only the department, and the judge seems to suggest that she had some concern for that. But again, his use and relapse historically is what led to his criminal history and his incarceration, which ended in January 2015 when he was released from jail for his second OUI. 2.5 years later, yes.
In terms of this time frame of what the judge considered, the department argues there was evidence that the father was unable to control his anger towards the mother and a department social worker, even in front of the judge at trial. What do you say to that?
So there's some suggestion, I believe, in the record that the mother mentioned something about the father looking at her or reacting to her testimony. It's not entirely clear to me from reviewing the transcript that anything more than just a witness, an observer in the courtroom reacted to some testimony that didn't sound accurate to them. I think it's important to note that during these court proceedings, despite this alleged anger that the father demonstrated towards the agency, the judge didn't have to remove him from the courtroom, didn't have to interrupt the proceeding. This was brought in as just an additional demerit against the father from the mother, who had already pleaded, had already stipulated twice to her unfitness and was supporting her family retaining custody of the child under the guardianship. So there's some motivation there to certainly not be allied with father. She also testified that when he wasn't drinking, his anger wasn't, his domestic violence historically wasn't a problem, and his anger wasn't a problem. And again, he had been sober since 2014. And also, as far as the anger goes, Justice Henry, it really was in the context of him dealing with the restrictions on his relationship with the child that the agency imposed. Came up early on in visits when the department resumed supervising the visits, and it came up in the context of agency hearings such as the foster care review and the family group conferencing. And in all of those, he was being told that he would not be parenting his child, that they were just trying to figure out what the visits would look like for him. And he was motivated to reunify with his daughter. He'd engaged in services, was focused on his well-being for that year and a half prior to the review and redetermination hearing. And he was motivated to parent. And by all accounts, the contact that he had with his daughter was positive. And she certainly looked forward to the visits. And in fact, thinking about his mental health issues regarding the anxiety that he was open about, for a period of time, he was taking a bus, hours of round-trip bus travel for a 1-hour visit that even so, he was able to set aside his anxiety and focus on his time with the child. So by the time of the end of the review and redetermination hearing, father's mental health was stable, and he was taking medication that was obviously assisting him. Does he wear his emotions on his sleeve a little bit? Yes, but in these cases, often the department will fault the parent if they show no emotion, just the same as they fault them for showing some emotion regarding what's happening with their child. And even the social worker who, the ongoing social worker who testified that she had some undescribable fear or uncomfort with the father, was reluctantly acknowledged that for the most part, majority of the time, the father was very appropriate during visits and demonstrated an ability to parent his daughter. And so the lack of deficits that the father had by April of 2017 were overlooked because the judge was concerned with the arc of his history more so than the changes that he had implemented in the year and a half before that hearing concluded. That lack of the even-handed assessment, which is pretty clear in the findings when it takes 130 odd findings before the judge gets to the current circumstances, and even then, within the flow of those findings, keeps reaching back, just like she does in the conclusions of law, to drag forward these facts that no longer had any vitality. So the father's past history was no longer prognostic. He had housing. He had a strong relationship with his daughter, and the judge recognized that with the status quo visitation order that she did make, that was to continue. And so to conclude that the guardianship was, first, the father was unfit, and that the guardianship was in the child's best interest, was an abuse of discretion by this judge under the circumstances. And the father is asking this court to vacate the unfitness finding and remand it for a hearing on his current fitness. And if there's no other questions, I'll rest on the brief.
Seeing none, thank you. Now I understand Ms. Hawk is taking 7 minutes, Ms. Bancroft 5, Ms. Blanchett 3. Is that correct? Okay.
That's correct.
Go ahead, Ms. Hawk.
Good almost afternoon, Your Honors. Natalie Hoke for the Department of Children and Families. In this case, the trial court properly determined that father has not made enough progress to resolve his unfitness since he stipulated to his unfitness in 2016. Importantly, father's rights have not been terminated. Father still has the opportunity to continue to make progress and to get to the point where he can achieve and might achieve fitness to parent his child in the future He's just not there yet.
Excuse me, I'm sorry to interrupt, but maybe I misunderstand. This is a permanent guardianship. So what would his burden be in a future proceeding, or is it your burden? How does a permanent guardianship without termination work?
So the department is still involved. Essentially, the case is off-listed, but father can apply for review and redetermination every 6 months. His rights have not been terminated. He just was found currently unfit, but that wasn't a finding of unfitness that's likely to continue in the indefinite future, like we would have with the termination proceeding. So every 6 months, father can actually file a review and redetermination, which he did here. He has the burden of production to show that his circumstances have changed, which he met here. And then the burden to prove that father remains unfit rests with the department.
And what is the department's position on his sobriety?
So the department acknowledges that he has made progress. He's come a long way, but at the same time, the fact that he minimizes his past, exaggerates his progress, and blames his criminal history, sobriety, and everything else on others is what is most concerning to the department, which demonstrates that he's likely to repeat that same pattern, everything from his criminal history to his sobriety. For example, the trial was held March 2017. Less than a year before trial, May 2016, father had 3 positive drug screens in a row for cocaine, yet he told his provider at Clean Slate, "I'm doing excellent." So father seems to not even understand the issues he's facing. So yes, he's in therapy. Yes, he's receiving treatment. Yes, he's made progress, but not enough progress to achieve fitness here.
And it seems like the judge, with respect to this oxycodone use, didn't quite, I don't know why judges do this, sort of recited the evidence, but didn't then find that he disbelieved that this was a Percocet from a dental appointment. Although he hints, or she hints, I don't know who the judge was, that that's what was going on, and obviously with someone with this history of drug abuse, there's reason for suspicion, obviously. So what do we do with that, if anything, or do you not rely on that?
We don't rely entirely on that. I mean, father's own testimony stands for itself. Is obviously he has 3 different versions of how many teeth he had pulled, so only one can be correct. The court pointed out the discrepancies. Whether or not he obtained the oxycodone legitimately, the department's issue is he never told the department that he was going to be taking oxycodone, which he had been addicted to in the recent past. And even though he met with his social worker immediately before that procedure, and they talked about the dental procedure, he never brought up that he was going to be prescribed oxycodone. And even though it's on his service plan that he cannot take drugs and he has to notify the department if he has, and he did not do so. So that's almost more important than the fact of whether he had 4 teeth pulled, 3 teeth pulled, or 2.
Well, it's not the teeth being pulled, it's taking an opioid that is troublesome to me,
Yes,
but I understand also not informing the department if required to. What about the marijuana use? I would have thought that someone who has a history of substance abuse and is supposedly in recovery shouldn't be smoking marijuana regularly. And yet I feel like there isn't quite evidence about the impropriety and danger represented by ongoing marijuana use. I think the judge says something like he doesn't treat it like it's a real drug or something, but does the judge cross that T and say, and it is a big deal? And what's the department's position on marijuana use in this gentleman's case?
So the judge didn't perfectly cross that T. What the judge noticed is that first the father would say, it's for, I use marijuana for back pain and for tendinitis. Then he said it's just recreational and just random. What the department's issue is he continued to use marijuana even after he was diagnosed with a cannabis dependency by his drug treatment provider. So even they recognized it as an issue. While there's no explicit findings showing how that inhibits his progress, it just goes to show father's blasé attitude towards his recovery and how that could impact his recovery and having not just his recovery, but having
is there testimony or evidence that the continued use of marijuana is inconsistent with recovery, or you're just asking us to infer that?
There isn't anything direct. I believe I was just reviewing the record, and it's hard to read some of the clean slate records, but it looks where father had asked clean slate to provide a letter that basically saying marijuana use doesn't have any impact on his sobriety. There is no such letter in the record that I saw. So we can't really infer from silence either. So while it would be better to make that finding that his recovery efforts are impeded by his current marijuana use, unfortunately, we don't have that, but this viewed in conjunction with minimizing all of his other issues and exaggerating his progress. For example, he got on the stand and denied he had anger issues, even though the exact same month he testified, the social worker had to leave his house because she was scared because he started getting very angry. And I know, see, my time's about to expire, but I just want to get in this last point. Father's attorney compares father to wearing his emotions on his sleeve, but shaking uncontrollably, turning red, throwing your arms in the air, and making others feel unsafe in your presence isn't the same as wearing one's emotions on your sleeve. So father crossed that line into anger management issues, which he continued to minimize and outright deny. So while some of his other issues in life he's made progress on, that issue was blatantly apparent at trial, and the other issues he's merely minimized, made recent progress on, but not enough. And if there's no other questions, the department rests on its brief.
Thank you. Ms. Bancroft.
May it please the court, Allison Bancroft on behalf of the child. The child is also asking the court to uphold the juvenile court's finding that the child was in need of care and protection and the granting of guardianship to her aunt and uncle. Father was unfit, as argued by DCF, based on a constellation of factors. And maybe none of these individually would have rendered father unfit, but together they all do rise to the level of unfitness, particularly where at the time of trial, there were two important factors that were still ongoing. One was his substance abuse. He did test positive to substances the first day of trial, cocaine the year before, consistently for marijuana, which for most of the proceedings was illegal, didn't become legal until December of 2016. And at the beginning of the proceedings, when the first trial was about to start, before both parents stipulated to unfitness, he also tested positive to morphine, oxycodone, and marijuana. He had a service task to maintain sobriety and not abuse alcohol or drugs, and this clearly is still an ongoing issue with father. The other issue that was still ongoing at the time of trial was his anger issues, and as DCF has argued, this was evident during the trial itself when the DCF worker was testifying. She noted that he was sending her dirty looks, that he was gesturing, standing up, crying. She had supervised a visit the month before where she saw him in front of child become overly emotional when a dog jumped in her car. He was swearing, he was yelling, he was screaming. And she testified that she didn't want to supervise any more visits because she did feel unsafe around him. Around that time as well, the foster care review took place. He was noted throwing up his hands, speaking loudly. DCF had requested a psychological evaluation and he never completed it. And clearly his ongoing issues with anger were still continuing at the time of trial. Again, this is not a termination case. This is not a case where the judge found that he's indefinitely unfit or permanently unfit, and he is able to seek a review and redetermination every 6 months to show that he has become fit. And therefore, the trial court's findings taken together do clearly and convincingly show that he was unfit, and the court's decision should be upheld. In terms of the guardianship, the child was removed in 2014 after 2 years of instability. Father was unable to assume parental custody at that time because he was incarcerated. She was removed twice in the fall of 2014. He was incarcerated both times. The guardians have provided a stable, safe, and nurturing environment There's been a marked difference in her from the time of removal until now. She had issues, speech issues. She qualified for early intervention. Her guardian had her evaluated. She's done all of those programs and now currently doesn't need any sort of treatments or any other special programs. She's in preschool. She's doing very, very well. She is still having visits with both parents, and the trial court was correct in finding that it was in her best interest to be placed in a permanent guardianship until such time as father could be found to be unfit. And therefore the child simply asked that the juvenile court's judgment be upheld.
Thank you.
Thank you.
Ms. Blanchett.
Please, the court, I'm Madeline Blanchett.
Okay, go ahead. I'm sorry.
Yeah, and I'm representing the mother. Just to follow up on a couple of things. One is that I do believe that father would have the remedy of going into the court and filing a motion to remove the guardian. So he would also have the review and redetermination as a remedy, but this is not a father who is permanently locked out from his child. So he has several remedies to come back in when he can demonstrate fitness. And another point that I would make is that while putting father's anger and hostility towards DCF, towards foster care reviewer in the context of someone from the government who's interfering in his relationship with his child, that's in stark contrast to his continued hostility towards mother in court that he demonstrated when mother was his victim. So there's no explanation for him to be unable to control himself around her, even in court. Another point that I'd like to make is that the mother certainly believes that it's in the best interest of the child to remain in a guardianship with the aunt and uncle. And the aunt and uncle, father even reported to the court investigator that he felt that the aunt and uncle were supportive of him. So it's really important to note that this kinship guardianship is not a place where father is being further alienated from his child. The aunt and uncle made all kinds of efforts in terms of the scheduling of the child's activities to enable visitation with father, and they even were willing to supervise it in their own home until they too no longer felt comfortable supervising those visits because of remarks that father was making and opportunities I guess he was taking to disparage mother. So I think most of the other points have been made by my peers. And if there's no further questions, I would rest on the brief.
Seeing none, we'll take the case under advisement. Thank you all.
Okay, we are live.
Very good. Our next case is 2019 P1210 in the matter of John J. King. Mr. Fulmer.
Good morning, Your Honor, and thank you, morning justices, for hearing this case. As a housekeeping matter, I just want to say that we obviously incorporate all of the arguments that are advanced in our brief, as we believe this is a case where there's a failure to proceed both statutorily and procedurally in the accepted protocol. Our position in this case is that the trial judge had an obligation to dispense with frivolous objections that are noted in our motion to strike, which is annexed to our case. We did everything we could to assist the court in making these preliminary determinations, but the court discounted the value of what was furnished to it, and thereafter, we believe, engaged in a systematic plan of exclusion of pertinent extrinsic evidence, lay testimony, while mischaracterizing the position and opportunity of the proponent, the absence of which would very well.
Counsel?
Yes.
So if the judge had struck the affidavits, your client still would have had the burden of proving the validity of the will, right?
Absolutely, Your Honor. Absolutely. Yes.
So how was there prejudice from not striking the affidavits?
Well, several components of prejudice. First, you're giving people who are perfect strangers a right to participate in the will contest itself, to verify the validity and to act on the issues of the validity of the will.
Well, I'm confused though. They're not perfect strangers. If this will was not valid, they would be taking each under our laws of intestacy, right?
That's correct, Your Honor. But the reality history of the fact is that neither Paul King nor Rubin Pelletier had a relationship with their father for more than a decade because they were hostile to him. One had
estranged.
Terribly estranged, irregularly estranged, Your Honor, such that a part of our extrinsic evidence that we were offering at trial included a series of restraining orders which existed between Rubin Pelletier and her father. She did everything she could to keep him away from her.
But that won't prove the validity of the will.
That's correct. It does not.
So what the contesters say, I'm sorry, what the contesters say is that the pretrial conference narrowed the issues so that the subject matter of your objections were no longer before the court, the undue influence and such. And only the validity of the will was going to be a subject of trial. Is that not correct?
She had left that open. The judge had left that open. And quite frankly, it wasn't until the second pretrial hearing that there was an attempt to restrict evidence, and the transcript is clear on that. And it wasn't until the judge indicated that she was not an expert and would not render an opinion as to the validity.
I'm asking a much broader question than that. I'm happy to give you time to talk about that. But what I'm saying is the judge bifurcated the trial, right?
Yes.
So what she was going to do first is adjudicate the validity of the will, and if the will was not valid, there'd be no reason to reach the other claims.
That is exactly what she did. Certainly. Is it correct? No, we believe that she erred in doing that. That she should have ruled on the motion to strike long prior to that event taking place, because if they had no standing, we would have been able to proceed with extrinsic evidence, and we would have been able to proceed without the use of an expert.
Okay, but I guess this all seems like a sideshow to me, right? You want a remand in order to be able to prove the will with extrinsic evidence, right? That's what you want.
Yes.
And you're going to have to do that. You also want the contestants to be out of the case altogether. Is that what you're asking for?
Our position is that they don't have standing, that they shouldn't have standing.
Okay, but they filed affidavits which said, leaving aside undue influence, all these other things. One thing they said was, one of them said at least, was that they didn't think the signature was legitimate, and they raised a few, I don't know how substantial, but the witnesses all lived near the son, not near where the decedent had lived, and he would have known if they were, right, whatever, it raises some question. So if that gives them enough standing to sit there and watch you prove it, but if on remand you're allowed to use extrinsic evidence, you're allowed to use lay evidence, and so on, isn't that what you need? What difference does it make if they're in the room or not when you prove or fail to prove the will?
Whether they're in the room or not means nothing.
Okay, so
whether they're entitled to object to various pieces of extrinsic evidence on the grounds of relevance or some other esoteric form, that's the problem here, and that's exactly what happened in this case. If you look at the
okay, but your position is that the judge was incorrect in saying there had to be expert testimony, right? That's your position. You want to be able to have lay testimony counted Or if she's going to say that it has to be expert testimony, you want an notice and an opportunity to present some, right?
We did, and we attempted to. And the order in which that occurred was that on the 23rd, at our second pretrial conference, she indicated that she was not going to rule on it as an expert.
Well, I understand that. I understand that. I read it a little differently than you. I don't read her to have said, I'm just not like other judges. I can't tell what goes on here. I read her to have accepted your brother's argument, and I'll ask your brother about this, that it was a matter of expertise, that an expert witness is required. You've cited a bunch of cases that suggest that's wrong.
That's correct.
Okay.
That's correct.
So the relief you want is what I'm trying to get at. And all this talk about affidavits and standing and whatnot, I'm just not sure where they get us. At the end of the day, you have to prove the will, right?
That's correct.
You want a chance to do that.
That's correct.
You'd like to do it without a contestant there. But these people are the heirs at law, and they say there's some reason to think maybe that isn't the signature of the decedent. Why isn't that good enough? And now let's cut to the chase and figure out whether you're entitled to remand or not. I'm sorry about the distraction with the video.
It's quite all right. Your Honor, our position was originally that we wanted to prove it by lay and extrinsic evidence. And that's how we set up our exhibit folders. I mean, it's quite plain. There are 15 or 16 different documents of either the testator or the witnesses, or certified documents that came from the registry or from other proceedings or from other courthouses that would have been available for purposes of the judge making a determination as to, i.e., the similarity, identical, or whatever. That exclusion came after the judge indicated that she would not act as an expert. And we never had, in September at the original pretrial, any indication from her that she was not going to act as the trier of fact. So we were relying on.
I have a related question. You claim that the judge erred in not letting you put in the extrinsic evidence, but it's like the exemplars to prove the signature. But you make no claim in your brief that the judge erred in excluding your expert witness. Is that correct?
Well, we believe that she erred in excluding it in the absence of her making
that claim. I'm sorry. Do you make that argument in your brief? Because I didn't see that.
I believe we do, Your Honor. By virtue of her not exercising her prerogative as a judge in the trier of fact, it's clear in the record of the proceeding. If you look at it, she says, I'm not going to be the trier of fact. And if you need an expert, I'll give you extra time.
She said she wasn't going to be the expert.
And indicated that if you read the transcript, it's clear. It says she would give us additional time. On 123, she first makes the argument that after showing her extensive exhibits on the extrinsic evidence, she's already indicating that she's not the expert. And on that note, that very day, the next day, my client hires an expert. We come back on a short order of notice and say, we now have an expert. And she says, well, if you do, I'll give you extra time. And then on 2-4, as the hearing is nearing a close, she says, no, my original order stands. There'll be no witnesses other than the litigants here. Well, that takes us out of an expert witness that we had hired. It took us out of being able to utilize that expert for purposes of proving the similarities or identity of the signatures of both the testator and the witnesses.
So can I ask you a related question? That there was a lengthy discussion about other documents and deeds that you claimed because you tried this that could have proved the signature and the signatures of the witnesses, but those were never put into evidence. Why is that?
They were objected to, Your Honor. We tried to put them into evidence in the last segment of the 214 trial. They were all objected to, and mostly on the grounds of relevance, and they were excluded. We were barricaded from putting in evidence of any sort, and I had my expert there. I said, fine. Can I put the expert on? Let the expert deal with the extrinsic evidence and let them do the correlation? She wouldn't hear it. We had no options.
Were the witnesses related to did your witness list include witnesses that could testify to the authenticity of the witnesses to the will?
Yes, Your Honor. We even had their lawyer. We had other documents that they had executed in their lifetimes that would have given the expert a fertile amount of information from which to make a determination.
And did you, when you say you attempted to admit some of these exemplars, those were offered to the court and then they were excluded? They were not admitted?
Yes, Your Honor. Specifically at page 82 to 86. And I can read it to you, or I can simply point to it in the text of the 2/14/19 trial. They objected, and the judge said all questions regarding the testator's capacity to create a will not be allowed to testify, and not allowed to testify as to his relationship with his brother and sister, and the certified documents being offered. There were other writing samples, and the judge refused to simply accept them. I mean, it was extremely frustrating. From the standpoint of attempting to put evidence in that we had diligently searched for months in order to compile. So we were.
And could you remind me, how many witnesses were there to the will? Was it 2 or 3?
There were 3, Your Honor. 3 witnesses, 2 of which were related, 2 brothers. Yeah, exactly. The Queeleys.
And they were all dead.
All 3 witnesses were deceased, Your Honor. And as counsel alluded to earlier, they all lived in very close proximity to both my client, the proponent, and his father, who quite frankly lived at that property for an extended period of time, and they were all friends. I mean, they were local neighborhood friends. That would have been a fact that would have come in had we been given the opportunity of showing where these people lived, what they did, how they were retired, how they knew each other.
How long had they been dead before the will was before the will appeared?
I believe more than a year or 2, Your Honor, was the last one that died. The will was written in 2013. The witnesses outlived the testator, and I believe that they had all died by 2016 or 2017. So that we missed the live witness boat by a year and a half.
The only question I have left is to make clear that you didn't notice an appeal from the denial of the judge's motion to recuse herself. You're just asking us to exercise our discretion. Is that correct?
Yeah, I believe we do have a notice of appeal on that. I've seen that on the record, and it's not consistent with my records of what we filed in this case. Although there's a lot of things.
Your reply brief said that you're not appealing that issue.
We do want her removed if you.
I understand that. My question is, and you said in your reply brief, and correct me if I'm wrong, that you are not appealing that, and instead you're asking us just to order her removed from the case.
That's correct, Your Honor.
All right, thank you.
Although there was a notice of appeal filed. We never assembled the record on that. We were more interested in the more substantive issues, and those are the issues that we're dealing with here. But yes, we would ask that you.
Where in the record is that notice of appeal?
It wasn't docketed, but we're gonna have to go through our file and get it.
It was never docketed, as my record.
How's it in a notice of appeal? It wasn't docketed.
It wasn't docketed by the court, but we submitted it.
We submitted it, Your Honor, but in fact, much of this case was not docketed until we filed our notice. And that much of it came back and was docketed after the fact. That's not uncommon in Middlesex, or at least it hasn't been in this case. And I apologize, but I was not monitoring what was taking place within the docketing room of Middlesex. I know that much of what is in this case is now docketed. It was docketed later. It was docketed after the fact. That much I'm aware of.
So you're saying if we were to look up the docket now, it would show?
I couldn't confirm that, Your Honor. No, I couldn't confirm that even today, whether it would show even at today's late date. One would think that it would, but maybe not. I don't know. I haven't looked at it, and I don't want to mislead you in any manner, shape, or form. I leave that issue to the court. That is to you. Our objective here is to obtain a fair and impartial hearing, which is not what we got. We got systematically foreclosed, first in the area of an expert, which we didn't think we because of the Okoli case. And then after, when the judge abrogated her position.
Mr. Fulmer, your time has expired.
Thank you, Your Honor. Thank you all.
Mr. Curhan.
Good afternoon. May it please the court, Dana Curhan for Robin and Paul. I don't want to spend a lot of time on the affidavit issue. I think it's a red herring. I think John Jr. has conceded standing, and what he's really objecting to has absolutely nothing to do with the issue that was handled in part one of the bifurcated trial. And the issues were sufficiently narrowed at the pretrial conference where I don't think we need to even get into that point. On the issue of what the judge actually did, I think the argument is that not that the judge declined to or failed to permit the expert to testify. She made that ruling on the February 4th hearing about 10 days before trial, and there was no objection to that. So at that point, the judge essentially said, look, we have two problems. If you wanted the expert, the time to notice the expert was in your pretrial conference report in September the year before. And I'm not going to do this by ambush. So,
Attorney Curran, you write in your brief, the court alerted the proponent well in advance of the trial to the fact that he did not appear to have sufficient evidence without an expert. But I didn't see a cite there, and what you're relying on now is a February 4th hearing 10 days before trial. So what's the record support for the idea that he should have known prior to filing the pretrial submissions that he needed an expert?
Well, I'm not sure. I can't really, because my computer's set up right now, I can't really look at the transcripts. I don't know. There may have been some discussion on the September pretrial conference. Pretrial conference. I could be wrong about that, but I think the judge made it very clear that he had the burden, and there are two ways of meeting that burden. The first way is by submitting it, by bringing in an expert. The second way would be by bringing in witnesses who could testify to the authenticity in some manner of that.
Wait, so you now agree that lay evidence is competent to prove the signature in a will. Is that right?
That's probably right.
Okay, so now you argued to the judge, it was, I don't know if it was you personally, whoever, counsel below, argued it's a matter of expertise. And that's when the judge, this is on January 23rd, and that's when the judge says, yes, I agree, it's a matter of expertise. And so I'm not going to look at this lay stuff. But you're now agreeing that's a mistake, that's an error. And she could have looked at maybe in her discretion she didn't have to, but she could have looked at that lay evidence.
I'm not agreeing with that. I think the judge was saying, if you don't have expert testimony, you need lay witnesses, you need lay.
He had a lot of lay witnesses on the witness list at the pretrial conference, in the pretrial conference report. So you didn't, or your clients, whoever, counsel below, said, no, that's not good enough. It's a matter of expertise. And then she said, yes, she agrees. Is it a matter of expertise as a matter of law, or lay witnesses are okay?
Lay witnesses are okay if you have the right lay witnesses. The problem.
So, go ahead, please.
The problem is that they didn't present the lay witnesses. They called. We had two witnesses, one witness by deposition, and the other.
They were told that lay witnesses wouldn't be considered. She said, "I'm not gonna be the expert here. Bring in an expert." Now, maybe that was, it's hard to tell from the transcript, maybe that was a matter of her saying, in my discretion, I do this all the time and I can never tell. So you bring me an expert. I'm not like other judges. Bring me an expert. Or maybe she was saying, mistakenly saying, as a matter of law, I need an expert. But either way, if she's doing the first one, she has to give him time to get an expert. If she's got a quirky view that she can't do it on lay evidence, or if she's mistakenly saying you need an expert, it's a mistake and she should let the lay evidence in, right?
I think what she's saying is that I'm not going to look at the signatures and compare them and determine that that these signatures are genuine or not genuine. I don't have the expertise. So if you want to go that route, you need an expert.
So she
Well, can I
announces
ask
that
a
on
variation?
January. I'm sorry, go ahead.
I just so things the statute says that if you don't have an expert, you can prove the authenticity through extrinsic evidence. That's section 3-406A. Okay. Now, when the exemplars, the extrinsic evidence, the exemplars were offered, they were excluded because the judge said or counsel below said, this is something you need expert testimony on, right? And so it's sort of a catch-22 now. So you've got, the statute says that if you don't have an expert, you can prove through extrinsic evidence. And then when they attempted to prove through extrinsic evidence, the judge essentially agreed that this was a matter that needed expert testimony.
If the judge was saying that you can only prove this by expert testimony, and she at the February 4th hearing was saying, you don't have, I'm not allowing you to bring in your expert, she would have ended it right there. What she allowed them to do was bring in witnesses and testimony and evidence showing the circumstances of the execution of the will. Now, that doesn't mean that, you know, if she brought in exemplars, the judge now has to say, okay, I'm going to look at these signatures and I'm going to compare them to the ones in the will. What I think the judge was contemplating was John Jr. was going to come in and say, okay, yeah, my dad drew up this will and he said, these three guys witnessed it. And he said it took place in the kitchen of this person's house and this lawyer drafted it, and bring in evidence of that maybe those witnesses listed on the pretrial conference report could have actually brought in. I mean, John Jr. did not bring in these witnesses. He attempted to say—
Mr. Carter, he did try to offer extrinsic evidence, and it seems that the judge thought that she couldn't decide this as the fact finder without an expert, and I think we all agree that that's wrong.
I don't think I agree that that's wrong. She couldn't decide the authenticity of the signatures. You know, I mean, and I think she could look at this and say, I'm not an expert. I'm not a handwriting expert. I can't look at these signatures and compare them and say, this is his signature and this is not, or this is not.
That's a matter of proof, though. You know, maybe the exemplars weren't sufficiently indicative of them being written by the same person, but the statute says flat out that in the absence of an expert, you can prove it extrinsically with extrinsic evidence. And the judge seemed to think nonetheless that she needed an expert.
I think the judge was saying, I don't have the expertise to do the handwriting comparison, which is the way John Jr. wanted to go. What she was also saying was that you can bring in other evidence. You can bring in witnesses who may have been there. You know,
they're
bring
dead.
in their wives, bring in their.
If the legislature says, yes, the judge can do this, and this particular judge says, no, I don't agree with that. I mean, does the judge either have to yield to that legislative judgment and exercise that power or recuse? If the judge just says the legislature is wrong about this, there's no way I can make this determination, then it seems like the judge, how can the judge proceed?
The judge is not saying you can't prove this through extrinsic evidence. What she is saying is that if you're going to prove it by extrinsic evidence, and the extrinsic evidence is, here are the signatures, you compare them and you decide if it's authentic or not. The judge correctly felt that she did not have the expertise to make that determination. Now, if you can state it another way, the judge could look at this and say, you haven't met your burden, but there are other ways of proving it.
But she wouldn't take the evidence.
But I think it wasn't offered. Now, this particular piece of evidence, the handwriting exemplars versus the handwriting on the will, she said, I don't have the expertise to determine whether it was or was not authentic.
Can I ask you a question that maybe goes a little beyond this issue where we're kind of going around? I want to get back to the affidavits and to standing. So am I correct that the case was narrowed before trial so that none of your objections or your client's objections were going to be litigated? All that was going to be litigated was, has the will been proved? Is that right?
Well, I think the objections as to the authenticity of the signatures.
So forgery, you believe, was still in the case?
Possibly.
Well, what I don't understand.
I mean, if it's not authentic, then obviously it was forged.
But that's not what I'm asking you. I'm asking you if the objections, I don't know, the burden is on one side or the other side. If all of your client's objections were out of the case and now it was just a case where someone had brought in a will and had to prove it like any other Thursday at the probate and family court or whatever, why are your clients still in the case?
Because they have standing to object to the validity of the will.
But you said that you all agreed that their objections to the validity of the will had been removed from the case. So I don't understand in what sense. Now, maybe I don't understand the relationship between proving a will and forgery, because to prove a will, you have to prove prove the signature. I don't know if that includes proving that it's not a forgery. Maybe that's something that can only be raised by a contestant. Do you know the answer to that?
Well, I think what was removed from the affidavits was things like undue influence and testamentary capacity.
What about forgery? That's my question. What about
forgery? Forgery, I think, was still in there. I think forgery was still in there.
And whose burden is it to prove forgery? Does the proponent of a will have to disprove it in every case, or only if it's raised and then the burden is on a contestant to demonstrate forgery?
I think where it's raised, then I think the proponent then has the burden of proving that the will is authentic.
So every time we have a will with dead witnesses, which is to say lots of the time, because wills are made in 1957, and then maybe the person who made the will survived all the witnesses, every single time the proponent has to prove not just, no, look, compare, that's the same, that's the same, that's the same, and it wasn't forged. That burden, I'm not saying that's wrong, I'm just asking.
Not necessarily if the signatures aren't contested. And in most cases, what you get is the signatures are notarized.
Okay, but they're not always notarized. I've seen lots of not notarized signatures.
Well, I mean,
right, it's not a self-proving will. There's no notarization. So now what's supposed to happen?
What's supposed to happen is if it's not contested, then the will is accepted. If it is contested, then the proponent has to present some kind of evidence that it's authentic.
Okay.
And when I talk about that, there are the legislature, I don't think, was saying the judge needs to compare signatures and become an expert. What the legislature is saying is that there has to be some extrinsic evidence. And it may be that the spouses of the people who witnessed the will, somebody can come in and say, oh yeah, that was signed in my signature and this is what happened. Or the John Jr. can come in and say, yeah, my father told me that Charlie, Frank, and whatever, witnessed the will, and this is the lawyer that wrote it. And that all could have been brought in, and it wasn't offered. So I think that's.
There was a Mr. Fulmer's concern about the objections was whether they are based on personal knowledge. And Robin's affidavit says that she questions the validity of the signatures based on her personal knowledge. Did Paul aver something similar?
I think he
about,
did.
He did, okay.
Unless there are any further questions, I'll leave the remaining points to the brief.
Okay, seeing none, thank you both.
Thank you.
Okay, we are live streaming.
Thank you. Our next case is 2019 P1412, Terrence MEEHAN versus Medical Information Technology Incorporated. Mr. Kobe.
Well, thank you, Your Honors. May it please the court, my name is James Kobe and I represent plaintiff Terrence MEEHAN. The question before the court today is whether Mr. MEEHAN's employer can terminate him solely for exercising his statutory right to file a written response to a performance improvement plan. In this case, the statute is the Personnel Record Statute. Now, our position is that terminating an employee purely for exercising a statutory right arising out of his status as an employee is a termination in violation of public policy.
So counsel, I take it that what you all seem to agree was a lengthy rebuttal that your client wrote, that is not in the record. Is that correct?
That's not in the record, right? Because again, this is solely the question of whether someone can be terminated for the act of submitting a rebuttal, not the elements of the rebuttal, not the elements of the PIP. It's just whether the act of submitting a rebuttal alone is a proper basis for termination.
Well, I would understand that, except that you do attach this email that that seems to indicate that that your client has some trouble behaving in a workplace appropriate manner. So whereas, we generally view the facts in the light most favorable to your client and reasonable inferences in his favor, where you don't attach the rebuttal, where you don't allege that the rebuttal was workplace appropriate, but you do attach this email indicating that he has some trouble with workplace appropriate behavior. Why is it reasonable for us to infer that his lengthy rebuttal was a workplace appropriate document, particularly where pretty much anytime you're going to have somebody who's engaging in a, quote, lengthy rebuttal in the workplace, that's not leading anywhere good
Well, I think that's a factual issue. That wasn't an issue that was any basis for the lower court's ruling or considered by the lower court. The whole issue was analyzed under whether or not the mere submission of a rebuttal under the Personnel Records Act was a basis for termination. And the judge ruled on a statutory basis or a legal basis that that was sufficient because the Personnel Records Act is not important enough or well-defined enough. And, as I'm prepared to argue, that is incorrect, I believe, as a matter of law under the relevant cases.
Well, I understand what you're saying about what the judge did, and we'll definitely address that. But it does seem to me that something has to indicate that that letter was workplace appropriate. And you don't say it, but you do attach an email that indicates it may not be.
Well, the email, I think, demonstrates that the rebuttal was the basis for the termination. Defendant has not suggested in any of their pleadings that it was not workplace appropriate. Defendant has handled this case as a case of a matter of law about whether or not the mere act of a rebuttal is protected under law.
Well, but let's test the proposition for a minute. If, in fact, the rebuttal was an obscenity-laden rant, would you agree that the employer could terminate the employee for submitting that rebuttal?
If that was the basis for the termination, and that, A, it's not factually true, but B, if the case goes forward and that is in fact the case, they can present that, but they haven't presented that. And I expect I think you would expect if that was the case, they would have said that as part of their response.
So you think that's a question, if at all, I take it, for summary judgment?
Yeah,
Because
absolutely.
your allegation is simply that he filed it, they met and talked about him having filed it, or whatever. We know they met, and he was fired for filing it. That's as far as this goes. That's all you allege, which isn't to say that it's factually true. It's to say that it states a claim.
Correct. Thank you.
So on the substance of how the motion judge ruled, can you say that Chapter 149, Section 52 serves a public interest that's not internal to the employer or the employment relationship?
Yes, I mean, and that falls under the rubric of whether the statute is quote unquote important enough. And I think the lower court judge confused that issue a little bit with the separate issue of whether the claim arose out of the internal policies or administration of the company. Now, she did quote to cases which did deal with the internal policies or administration of the company, the Smith-Pfeffer case and the Wright case, where employees saying, I don't like the way things are being done. And the court said, we're not here to rule on that. But the King case did deal with a statute. In that case, the derivative rights claim statute. And the court in that case, I made two statements, which I think are sort of the keys to the case. In the first one, it said redress, this is at page 582 of the King opinion, redress is available for employees who are terminated for asserting a legally guaranteed right, for example, filing a workers' compensation claim. And that is very similar to what my client did. He filed a rebuttal.
But
as a
what,
statutory
can you
right.
just tell me what the public interest is?
The public interest is that the statute not be, well, let me read the second quote and then answer that question. It also held in what I think is the key provision, quote, for the exercise of a statutory right to be worthy of a protection in this area, we believe that the statutory right must relate to or arise from the employee's status as an employee, not as a shareholder. And in short, importance is really a shorthand, I believe, that the courts are using for the concept of how closely the statute relates to your status as an employee or arises out of your status as an employee. So therefore, you know, in the abstract sense, a workers' comp claim is no more important than a derivative claim. But when you view it in terms of status as an employee, the workers' comp claim is more important because it arises out of the status as an employee, whereas the derivative claim arises out of the status as a shareholder.
Mr.
Separate and
Cobley,
apart.
Mr. You have to allege more than it merely violates public policy, right? You know, under the pleading requirements, you can't just throw in conclusions to get by the dismissal. It needs to be substantiated with actual things, and furthermore, I think you'll agree, not every violation of a statute necessarily implicates public policy concerns.
Well, I agree, and I think the King case says that not every statute is important enough
right
to
so
be a violation. But I think what they're saying is if it's a statute that arises out of your status as an employee, it is.
Well, I understand that's your argument, but nonetheless, we've already said in the Kessler case that the remedy for under Section 52 does not involve monetary damages.
Yeah, but I'm not suing under the Personnel Records Act for a violation of the act. I'm saying my client exercised his rights under that act and was terminated for it, and therefore that termination due to his exercise.
I'm sorry to interrupt, but you still have to establish that the violation of the act violates public policy. And if this court has already narrowed the remedy under that statute to the Attorney General's involvement in fines, why isn't there already been a determination that this does not involve public policy and that you cannot do an end run around it by making a public, common law claim?
Well, I think my view is I am not alleging a violation of the act itself or the terms of the act itself. I am alleging a wrongful termination. And my view of the law is that if you terminate someone for exercising their rights under an employment-related statute, that in and of itself is a wrongful termination, separate and apart from the underlying provisions.
Every violation of a statute then involves public policy.
Any violation of the statute that arises out of your status as an employee. And yes, I believe that's the case. Now, the one, and I think that division clarifies all of the cases. The one case that is most difficult to analyze is the Parker case, the appeals court case in which the employee was terminated in the context of a job elimination for budgetary reasons. And I think what the appeals court was really doing in that case was saying two things are going on here. The town is deciding to eliminate a position for budgetary reasons, and because of that, an employee is also losing her job. But I think the reason the court upheld that decision by the town was because it was viewing it primarily as a job elimination for budgetary reasons decision and not a retaliatory discharge for exercising rights under the act. But again, my position is if the defendant's position is upheld in this case, the court will have effectively repealed the Personnel Records Act's protections, because any employee who wants to file a rebuttal will know that the very act of filing the rebuttal could result in his termination. So therefore, the act has no protection at that point forward.
So, Counsel, I'm going to try again here. What is the public policy that's external to the employer?
The public
I mean,
policy.
so
well, I think when the legislature passes a law that says employees should have certain rights, the legislature has said this is an important policy worthy of protection, and that in this case, it's the right to react to what the employer is saying and try and correct that. But I view when the legislature passes the law on a subject, they are saying this is an important policy and an important right for employees. And unless the courts are allowed to enforce that.
The public policy then is the policy of ensuring that the employee has a chance to rebut allegations about himself that are in this employment record that may be seen by subsequent employers, or
well, I would say it's not just subsequent employers, because sometimes employers have a mistaken view when they place employees on personnel.
Oh, I see.
And the employer can say, no, you're wrong for X, Y, and Z reasons. And sometimes the employers actually change their mind.
So are you saying the public policy is to try to keep people employed?
Well, I think it's more a fairness issue, that people have a right to express their opinions about their employer's discipline about them, whether it may affect them in the future, whether it may affect them in their personal job. But
it's a procedural right, like a union's right to have terms of employment bargained over, which doesn't give you a right to a particular outcome, but it does give you a right to insist that before something is unilaterally imposed, that there is some kind of interaction about it. And that's what's being protected here in an attempt to ensure that wrongful terminations or adverse employment actions aren't taken.
I think that's true, Your Honor.
So if the statute does not provide a monetary remedy or a damages remedy, why can you, so if the employer just said, no, you can't file this, there's no monetary remedy, but where the employer terminates the person, then the person you're alleging can get monetary damages?
Well, again, I'm not suing for a breach of the statute. I'm suing for wrongful termination under common law. And whatever common law remedies there are for wrongful termination, if I succeed. Now, obviously, this is just a motion to dismiss level. But yes, if he succeeds.
You've sought equitable relief as well.
In terms of job reinstatement?
Reinstatement, yes.
Yeah, I mean, that's an alternative remedy. I think that's unlikely, but.
I understand.
So again, my basic point is the King provision is the crucial one. This is an important statute under the King analysis because it arises directly out of the status of an employee. And if this termination is upheld, the statute will effectively have no force or value for employees. Thank you.
Thank you. Mr. Brewerton.
Thank you, Your Honor. Members of the panel, may it please the court. I'm Scott Burden from Medical Information Technology, Inc., which does business as Meditech. Your Honors, there are two threads that consistently run through the case law concerning the public policy exception to the at-will employment doctrine. The first is that the public policy exception is very narrowly construed so that we don't end up converting the general at-will rule into one that requires just cause for termination. The second is that an employee's objections to the internal administration, matters, and functioning of an employer cannot form the basis of the public policy exception. And in accordance with those two common threads, courts have consistently required that the public policy invoked be both important and well-defined. And the rebuttal mechanism contained in the personnel record statute does not rise to either standard.
Well, counsel, what is the purpose of this statute? Why do we say the employer has to have this opportunity for the employee?
So it was brought up previously that, personnel records might subsequently go to a third party for subsequent employment. But in that case, the expectation is that the employee.
We've lost your audio.
You've lost your audio.
Excuse me, can you hear me now?
Yes.
So it was mentioned that personnel records are occasionally transmitted to third parties, but the expectation there is that the employee's rebuttal is also transmitted along with the employer's other documents if the employee disagreed with those. Also, it was mentioned that occasionally employers do change their mind when they receive a rebuttal, but that really speaks to how uniquely internal a personnel record is. Personnel records are defined by the statute as records relating to the promotion, compensation, and discipline of an employee. That's an internal document. And if there were some.
What I'm hearing is that the rebuttal may serve a salutary public purpose of keeping the person employed with this particular employer, and it may assist allowing the employee to be employed by another employer. In other words, that we're keeping them off of the public fisc, and that is a valid public purpose.
I would argue, Your Honor, though, that the employer also has an interest and a right in determining or making its business decisions as it sees fit. In most cases,
So do you think that employer can terminate an employee just for filing a rebuttal, the most beautiful, exquisitely phrased rebuttal on the merits, no issues with workplace appropriate behavior? The employer should be able to terminate the employee.
I would argue that they should be able to do so, Your Honor.
That's your position here, right? That's all this is about. You're not saying that anything he said in this rebuttal was improper. Your position is he filed it, we can fire him for that.
So given the present posture of the case, yes.
And fire someone for filing an I-9 form.
Well, the I-9 is required by the employer.
No, it's required by federal law.
Correct. So
now they file their I-9 form. It doesn't say anything wrong. It says they're a citizen. You fire them. Can you?
In that case, it would be an at-will termination. The employer.
So
yes.
Thanks for filing the I-9 form. You're fired. How about filing a W-4 or whatever you have to file to tell how many deductions you would have?
Under the at-will rule, an employer can terminate an employee for no reason at all. So
I understand that, but that's not the same as for these reasons. You can fire an employee for any reason at all, but not because of their race. You can fire an employee for any reason at all, but presumably not for taking family and medical leave and so on.
Correct. And I think that really underscores the shortcoming of the plaintiff's position is he's asking you to elevate form over substance. he's asking to say, in Smith, Pepper, and Wright and King, had those employees made those objections in the form of a rebuttal to their personnel file, those cases should come out the opposite of the way that they did to begin with.
He's saying it has nothing to do with the substance of what's written. He's saying the only thing you can't do, you can read it and you can say, what kind of clown is this we've employed? You're fired. But when it arrives at your desk and you open it and you see, oh, this is the rebuttal form he's authorized, he's permitted, or that we're required to accept by state law, you're fired for exercising your state law right. That's okay. And that's
under the narrow public policy exception, yes, and I would direct the court to Parker v. Town of North Brookfield. In Parker, the plaintiff was applying for health insurance to which she was statutorily had a right to obtain that health insurance. And this court held at 241, the employee was, quote, terminated solely for exercising her legally guaranteed
That's because it was going to cost you money, right? Or cost the employer money.
And I would argue that that's kind of the court even acknowledges that if it's because it's going to cost the employer money, this is a just cause termination.
Well, but this doesn't cost anything. It's the receipt of a sheet of paper. It's that he's allowed to file.
And I would argue, Your Honor, if the employer does not find that persuasive, and particularly in the context of a PIP where the employer is providing constructive criticism to the employee, the submission of the rebuttal may lead the employer to assume this employee is not going to get in line with the performance expectations that we have.
Notwithstanding that we're talking about not looking at the words he's written. So he files a thing and it just has one correction. It says, they said this happened on a Tuesday, but just for the record, I don't know that it makes any difference at all. It was actually Wednesday, May 17th that it happened on. I can't believe that this guy would file this thing.
And again, I would go back to we don't want to elevate the form over substance. If the employee is complaining about an FMLA violation, is complaining about discrimination, the employer terminates an employee on the basis of a rebuttal at their own peril. Very likely the employee would have a retaliation claim in addition to their underlying claim of discrimination or of an FMLA violation. I would also argue that as applied to this case, the defendant, right within their complaint, in paragraph 6, discusses his dissatisfaction with the reorganization. In paragraphs 9 and 10, discusses his dissatisfaction with the supervisor's management.
But you've already said that the procedural posture of this case means we are supposed to be deciding only on whether filing simpliciter, this statutorily authorized rebuttal, can be the ground for termination. I mean, my guess is, and I have no idea, that you would win on summary judgment, that there might be facts, lots of facts that warranted dismissal, maybe even in the response. But that's not where we are, right?
Well, not at the present stage, but I would point the court back to, again, this is a very, very narrow exception. And the plaintiff is really trying to broadly expand that. And as Justice Meade pointed out earlier, expand it beyond the Kessler decision and the statutory remedy that is provided for in the statute.
Mr. Brewerton, why doesn't this implicate public policy? Rather, I mean, I understand that that's construed narrowly, but what actually is your position on why this doesn't violate public policy?
Because it is such a uniquely internal document, and furthermore, I would point out the statutory language that allows an employee to submit a rebuttal for any disagreement with their employer without limitation. And furthermore, it allows an employee and employer to agree to remove information from a personnel file, again, for any reason without limitation. If the legislature thought that this serves some greater public purpose, it would not have allowed employers and employees to remove any documentation without limitation. It would have wanted to place some limits around there and say, listen, this information is so important as a matter of public policy that it cannot be removed from.
Can the government pursue policies that try to keep people employed?
They can under the personnel, but however, that would be really a step beyond. It would be almost a repeal of the at-will employment doctrine and moving towards a just cause provision. In a number of these cases, they know, yes, employees do have an interest in keeping and maintaining employment. Employers have an interest in ensuring that they can run their businesses as they see fit. And then the public also has an interest in dissuading frivolous lawsuits from proceeding. And this goes to the well-defined aspect of this case. As the Superior Court noted below, if we allow employees to pursue a claim every time they submit a rebuttal to their personnel file, particularly where they can do so for any reason, it has the potential to open up the floodgates of litigation, and employees will essentially be able to haul their employer into court, where the employer would then have to justify the termination, and we'd be asking the courts to act as super personnel departments to second guess the employer's business judgment. And that's a proposition our courts have regularly rejected taking on.
So counsel, if, the plaintiff argues that if we don't rule in favor of the plaintiff, in favor of this right to file and have the rebuttal put in their file, that we're basically writing the statute out of the law, and that's not our prerogative. That's the legislature's job. What do you say to that?
I would disagree, and the plaintiff has already conceded that we did not violate the statute. He submitted a rebuttal. He did not prevent the rebuttal from going in. He does not allege that we
right, but he's saying that if we rule that the employer can fire the employee simply for filing the rebuttal, that we've basically gutted the statute, that we would chill any employee from ever filing a rebuttal.
So I disagree with that, and I think really that's an argument that the plaintiff would likely need to take up with the legislature. The legislature defined the remedy right within the statute. It says the employee has a remedy through judicial process to have false and erroneous records expunged from a personnel record. And Kessler held the same. It said the only remedy available to employees under the personnel record statute is to correct, comment, or expunge false information. What the plaintiff is asking you to do is really expand the statutory language to provide for legal damages where he otherwise would not be able to obtain them. As the court noted in Kessler, legal damages are not available to employees under the personnel record statute, and the plaintiff is now looking to circumvent that statutory language. And
assuming the employer just said, no, we're not taking your piece of paper or your lengthy rebuttal, what would the damages be?
So then I would argue that the plaintiff would have the ability to go to court and seek judicial process to have the rebuttal added to the personnel file. Or assuming something in the personnel file was erroneous, go to court to have that record removed if it were erroneous. But the statute does not provide for money damages, and in past precedent of this court, the court found that money damages are not available under the personnel records statute either. And the federal court has relied on that as well. In Lugoti, the court said, no, you cannot obtain money damages for instance, an employer's failure to provide a personnel file on time. Now that was a district court case and in the federal courts, and so I understand that's just a persuasive precedent, but the federal courts are relying on that language in Kessler as well. And I believe in the Lugoti decision, the court even noted that the plaintiff there could not rely on a common law theory. And that shows kind of how novel the plaintiff's argument is in this case. The personnel record statute has been on the books since 1986, this particular provision unchanged. And just now is pursuing an argument saying that anytime an employee employee submits a rebuttal to their personnel file, they should receive protection that wasn't previously recognized.
Well, it's a little odd to fire somebody for submitting a piece of paper they're allowed to submit. I'm guessing it hasn't come up much, right? I don't understand why your defense hasn't been, we read the piece of paper and then fired him, but all right.
And I certainly would argue that that is the case. I mean, it strains credulity to think that Meditech would have fired someone without reading the report. And yet, as a matter of law, I would argue that an at-will employer is entitled to do so. I see my time has expired, but
seeing no further questions, thank you both. We'll take this under advisement.
Thank you very much.